financials in the McStay family murder case. Prosecutors really pushing that motive there. And of course, as you guys always know, motive is not a necessary element in the proof of a murder case, but you sure like to have it when you're a prosecutor. Guys, we have a debut performer here at the Law and Crime Network, a force multiplier to the Gene Rossi Bianchi team, Natalie, Elisha Gold. Welcome to the set.
Thank you so much, Bob. Thanks for having me.
Yeah, awesome. So you are an attorney in New York and New Jersey and California, and you're also a wealth management expert?
Yes.
What is that?
So I do a lot of wealth training, and my expertise is in estate planning and probate. So I deal with a lot of people about what wealth can do. And this, in my opinion, is a wealth case gone really ugly.
Right. Well, I don't know if you can look like right ahead of you right there. You see the great Gene Rossi.
Hi, Gene.
Yeah, he's what we call hashtag 4041 because he shot 40 points in a high school game and then followed it up with 41 points. He was with the DOJ for close to 3 decades. They've actually got a room. You're not going to believe this, Natalie. They got a room called the Gene Rossi War Room, dedicated to Gene after he left the DOJ. So he's a pretty impressive figure.
That's amazing.
Yeah, I honor and worship his talents. So let me ask you, what's your take in terms of the prosecution's relentless pursuit of the financial records in this case, and are they scoring points?
I think they have to be, because otherwise I think a jury is going to be hard-pressed to really pin it on why. Although maybe it's not required under the law, as people, we all want to understand, why did something happen? And I think pressing on the financials is the key here.
Yeah, now Natalie, just tactically speaking, from a trial point of view, we've talked about this case. I mean, the brutality of the murder is unbelievable.
Oh my goodness.
You know, a whole family wiped out, which is typically more than if there's a money motive. I found in my experience as a homicide prosecutor, they kill the victim, but they don't really take and wipe out an entire family. So there's that level of brutality there. But this case was also kind of mishandled from the beginning, where they thought it was a missing persons case, then they thought the family, they had pictures of them going over the border, and then years later they're found, their remains are found brutally, skulls smashed in, crime scene wasn't processed properly at the scene. There's also this allegation of a third party, Dan Kavanaugh. Now our great Kathy Russin has indicated that yesterday Dan Kavanaugh the evidence came out that he was in Hawaii, that's the alibi, and that alibi was supported by PayPal evidence from witnesses that came in to indicate that card was being used over and over again. And while I get that he's got that alibi, Gene Rossi and myself have kind of talked about the idea that maybe somebody hired somebody to do this kind of person who doesn't care about taking out an entire family or how brutal they do it. What are your thoughts?
I think you're probably right. I think that people today can really, if they're smart and planning, can pull something like that off. And you have to really consider a family of 4 wiped out just like that. There's more to the story than we're seeing at first blush.
Yeah, Natalie, to that point, it would not be the first time ever in the history of homicide prosecutions, I can tell you firsthand, where somebody creates an alibi for themselves, maybe even goes out, has somebody else do it, or has somebody else have that information so that it looks like they're somewhere else where the crime is committed. Have you experienced that in your wealth management capacity when there's financial motives in cases like this?
Absolutely. And even further, taking that one step further, the entire digital world is so wrought with fraud. It's costing companies $50 million a day in fraud. So this person could have very well have done this, and it's probably not so hard.
Right, right. And Gene, you know, in most jurisdictions, and I would imagine here, there's a jury charge that's very brutal to prosecutors at the end of the day. And folks,
yeah.
If you don't know what your jury charges are, that is what they're going to tell the jury at the end of the case. I would tell my baby assistant prosecutors, my younger assistant prosecutors, I don't mean that pejoratively, that then you don't know what it is that you're trying to build a case for. And at the end, it's called the lack of evidence rule. And they say that you could find a person not guilty based upon the evidence or a lack of evidence, a failure to do something that you would expect law enforcement investigators to do. And to your point, Gene, you raise a great one in my mind. What did you do videotape-wise or other electronic-wise? There's digital footprints all over the place to support the use of this financial records in Hawaii. Natalie, I mean, this can cause reasonable doubt.
Absolutely, Bob. And I'll tell you that I often train young lawyers in negotiation. And I tell my students, when we are getting up there, it's the beginning and the end that matter the most. The middle often gets lost, and that's in a 50-minute negotiation. Can you imagine day 41 and we're still going over the same testimony? I mean, people are going to be looking at this like, what happened 3 weeks ago?
All right, so we'll put our objectivity hats on and get past the emotional trauma of listening to what this all means in the real world. But Natalie, these are real people. These are jurors. They're listening to this officer who eyewitnesses the fact that he takes this girl in one swoop, throws her over, she screams. God almighty, you can only imagine the horror for this kid. Splash in the water. This cop is left with quote unquote little options. He tries to get down the ladder. He's not able, screaming out to the child. The reason I bring this up is that the jury is deliberating the insanity defense. And the insanity defense isn't that I'm odd, isn't that I'm emotionally disturbed, isn't that I have a mental health disorder. It's that I have a mental disease or defect to such a level that at the time the incident happened, they could not form an intent. They could not appreciate the difference between right and wrong. And when he gets, I found very compelling to me that when he does that, he throws the girl off the bridge, his daughter, he gets in the car and flees. That to me is consciousness of guilt. And when you look at the gravity of what occurred, no matter how messed up he may be mentally, I just don't, nothing that he did showed that he did not know that what he did was wrong. In fact, it showed he did know. Thoughts?
Absolutely. And the fact that the officer said that he specifically said, you have no free will. To me, that means that he knew consciously that he was making this decision. He might have been trying to blame it on, I have no free will, I have to do this. But even in saying that, you're saying that I understand what I'm doing here.
Right, right. Fleeing suggests strongly, loudly to me, you know exactly what you did was wrong, and you were fleeing not just anybody, you're fleeing the cops, Natalie.
No doubt about that in my mind. He knew what he did was wrong. He ran away from the cops, and shame on him. I think the jury found in the right way.
Sure, and Natalie, but it goes to the point that we always train prosecutors, like Gene and myself did for many years, is that you as a prosecutor have to make sure over and over again, you go through your evidence review, you go through your file. That was a killer piece of evidence, no pun intended, that would have blown away the defense case here, but it was excluded. And so just because you know it to be true, and we know it to be true, if the jury doesn't hear it, like, you know what that reminds me of, Natalie? The O.J. Simpson case, when the prosecution never introduced the Bronco ride with Al Cowlings, a ski mask, $10,000 in cash, and a gun. I would have been there as a prosecutor saying, if those are the actions of an innocent man, then you find him not guilty. After he finds out that his kids are orphaned, that's what he does. And when the jury had heard that afterwards, they well, that would have been profoundly important to us, but the prosecution never admitted it.
It's astounding to me that that didn't come in. That is to the heart of the issue, and any justification or excuse of insanity would have been blown out of the water. Thank goodness the jury still, in my opinion, found in the right way.
Yeah, okay, Gene, we talk about it all the time. We know a lot of lawyers watch us on the Law and Crime Network, and a lot of law students that are learning to try cases. I don't care how sophisticated your defense or your prosecution is, nothing is better than common sense arguments. And on that note, we're going to take a break. We'll be right back. I agree with Gene. It was quite a cross-examination and another example of great lawyering by the prosecutor in the case. I think the prosecutor herself was shocked when she started saying that she felt that she had the authority to poke the child and hit the child. And what I liked is I saw a moment with that prosecutor where this thing went on that I think she had a lot more to cross on, but she said, you know what? When you stand well, stand still. I didn't expect to even get anywhere near this. And she had the smartness to pull out of that cross and sit down. What do you think?
Absolutely. Like my husband always says, when you get a yes, walk away. Thank you very much. Goodbye. And that's exactly what the prosecutor did here. Now, that the fact that she even thought she had the right to do that to someone's kid, that's beyond.
Yeah, and you know, one of the things that, you know, like I said, the testimony was bad enough because that's happening in front of the jury, but there's also all this wobbliness in her answers that she gave to the police. And again, if you're going to instruct somebody on as a criminal defense attorney, what do you tell them? It's the golden rule. It should never be violated. Again, I go back to, it's what the first lawyer said to the caveman, don't speak to the police unless you're with me, and I think it helps you. But many of these people I've experienced think they can talk their way out of it. All right, guys, I want you needs to answer this question. I know that we've been debating internally here at the Law and Crime Network about whether she should take the stand or not. But then you see the police clip there where you know that she's basically saying she was having some physicality with this child over her squirting, I think, ketchup in a toilet bowl. And there are some that believe that simply because it's a child abuse case, the defendant should have to take the stand in order to exonerate themselves. I find that to be, I've never heard of such a theory, because in the end, Natalie, she's going to have to explain away those statements to the police. And on cross-examination, and I know our great producers are kind of putting something together for us so we can show the audience, you know your client's going to get hammered on the stand. I would argue differently. I would not put a client on the stand, especially when it's going to implode. What do you think?
I never would have put her on the stand. I think that it did her no service, clearly, and the fact that she even went up there and was able to speak at all is beyond me.
Yeah.
Yeah, as a defense lawyer, Natalie, Gene's point, and me and Gene always talk about being aware of everything that's going on in the courtroom. I had a cross kind of similar to that one time where the defense attorney literally was putting his hands in his head in his hands, and I just stopped asking questions and just kept, looked over at him so that the jury's attention was brought over to him. And so that goes to the practice point that you got to be careful because the jury's watching everything, and that was an inartful move by the defense lawyer. But I agree with Gene. This defense lawyer must have been, oh my God, help me.
Absolutely, and often you have to have a poker face, but the defendant certainly did not, because she said, yeah, sure, I slapped her with an open hand. What, like it's a big deal? That was all the jury had to see.
Well, there's a photo of that little angel right now, and we remember her and pray for her. And so, guys, listen, we got some business to do here at the Law and Crime Network. We have been really covering a lot of subject matters with Gene and Natalie, and we will be back with more. Stick with us, and if you're not in that chat room, get in there. I'm getting ready to answer some questions. Wow, it's a great day here at the Law and Crime Network because I got great guests. We had great topics to cover. And the producer actually asked me before I leave at 3 o'clock, is there anything in particular that I'm interested in actually presenting? And there is. I just cannot get over this Jussie Smollett. I never heard of the guy before. I never heard of the show before. It shows you how backwards I am. I'm just all about law and crime. And since he is involved in law and crime, we're going to break it down a little bit more with Natalie and Gene. We got a little bit of a precursor here from the great Jesse Weber from the Law and Crime Network. Let's take a look at it before I'm going to go full tilt against this district attorney, Kim Foxx. We'll be right back.
After a grand jury indicted Jussie Smollett for allegedly staging a hate crime against himself, Kim Foxx texted, "So I'm recused, but when people accuse us of overcharging cases, 16 counts on a Class 4 becomes Exhibit A." When Foxx's office later dropped all charges, it ignited a firestorm of criticism, including from the mayor.
This is a whitewash of justice.
Foxx went on to call Smollett a washed-up celeb who lied to cops, and basically said Smollett was overcharged, comparing the 16 counts Smollett faced to the 10 faced by R&B singer R. Kelly. She called R. Kelly a pedophile and said, just because we can charge something doesn't mean we should. Foxx's recusal has become a point of contention in the Smollett saga. She said she removed herself from overseeing the case after speaking to a Smollett family member while the case was being investigated as a hate crime, not a hoax. But Foxx did not legally recuse herself. Doing so, her office said, would remove her team entirely and require the appointment of a special prosecutor. I'm Jesse Weber for the Law and Crime Network.
This makes my head explode, okay? Because I'm trying to figure out, folks, whether or not this was for her own political advantage, personal advantage, whether or not she's just merely incompetent, whether or not she understands the criminal justice system. There's so much shade that is thrown on us with those comments. Let's start with the most stupidest thing she said, equating this case to the R. Kelly case. She got the line, just because we can doesn't mean we should. I agree, District Attorney Foxx, that's true. But doesn't mean that the number of charges is what's relevant. It's the manner in which you resolve them. This This guy set off a firestorm of potential racism, lied multiple times to police officers in this case. You cannot countenance somebody who does that because you're basically undermining lawful, legitimate, non-obstructive cases. Now, that said, the number of charges doesn't make a difference. A murder case only has one charge, and that's murder. It doesn't mean it's any more or less. These were minor offenses, perhaps in your mind. You indicated in your own text that you believe that she should get, or he should get rather, an alternative disposition. You didn't even do that. You dismissed it. And then the last thing I have to say before I go to our great guest is, what do you think your wool you're pulling over our eyes? It's your very office that presented these cases and these counts to the grand jury. It is the 23 citizens of Cook County that came back with an indictment and said he was responsible for all these and should be held over. And with all of that, the case you presented, whether it be one charge, whether it be 50,000 charges, you made a decision that the just result for lying, creating racism, deprecating those hate statutes that were there to protect real victims of crime is to dismiss it. Then what the heck did you present it to the grand jury for in the first place? This case gets me so agitated because it's rotten to its core. Natalie.
I couldn't agree more with you. We have such divide in this country right now. And to add fuel to the fire, why? Why? I just don't understand it.
Right, and Gene, this whole concept that's out there that people think, well, he got 16 charges and R. Kelly only gets 4 charges and this one only gets 1 charge for murder. This is, it just these are text messages. So I'm going to presume she was believing what she was saying. It's not about the number of charges. A number, 16 fourth-degree offenses are different than 1 first-degree offense. You don't base a case based upon the number of charges. You base it upon what the appropriate resolution was going to be. And if you were going to dismiss it, what the hell did you present it for in the grand jury anyway? I'll tell you what my thoughts are, Gene. She wanted that grand jury to no-bill it. She wanted that grand jury to walk away from Jussie Smollett, but the prosecutors lost control of the grand jury, which is rather unusual, and they came back with the charges, and then she was stuck with them, so she dismissed them. This just sickens me, Gene. It's disgusting. She should be removed from office. You know what? Perhaps worse than her personal gain is these texts demonstrate a complete lack of understanding of how the criminal justice system works.
I agree with 99% of what you said, but I disagree that they wanted a no bill.
I'm saying it's a possibility.
When those prosecutors initially presented it to the grand jury, I think Kim Foxx was actually recused. And when they returned the 16 counts, which was way too much, should have been maybe 4. When they returned 16 counts, I think Kim Foxx got holy hell from people, and then she got back into the case, and this canard that she can't get off the case, will have to have a special prosecutor. That is absolutely a lie.
Gene,
I want to say this. That is a lie.
Let me retort.
She can recuse herself.
I know for a fact head prosecutors who want the case to go into the grand jury, so the grand jury makes the decision to no bill a case as opposed to them because they don't want to take the political fire. Whether that happened or not, I don't know. I don't think it was overcharging isn't the issue here. To me, the issue here is how it's resolved, and a dismissal isn't the appropriate way. I got to go. Thanks, guys. We're going to be quick. More Law and Crime left. Don't go anywhere.